Good morning everybody, Mark Dawes here. I just want to follow up from a video I did which was must I as a trainer hold a teaching qualification, because in that video I mentioned about competency, and a question I got asked was, how do you measure or how do you assess competency? And that question came from Stuart Nicol, who is an absolutely brilliant and competent trainer in his own right. And I answered that question for him in a thread, but I thought I'd share that response with you because it may help some of you out there. Now, it's not an exclusive answer, it's not the definitive answer, I'm sure, and I'm pretty sure some of you will be able to add to it. But I just thought it may help, so I'm just putting it out there for you guys, and then if any of you can actually add value to that, then please leave a comment below. But this is what I've found out anyway. A competent person is viewed in case law, Skibs v Gibson 1964, as someone who knows what they are looking for, can recognise it when they see it, and although not mentioned in the case, then knows what to do with it. In short summary, competence has been defined as having the possession of sufficient knowledge, experience and skill to enable the person to know what he or she is doing and to be able to carry out a task in the way in which a person competent in the activity would expect it to be done, and to have an appreciation of one's own limitations. Now, the Crown Prosecution Service have also provided a definition of competency, which is as follows. A witness is competent if he or she can lawfully be called to give evidence. The principle is set out in section 53(1) of the Youth Justice and Criminal Evidence Act 1999 that at every stage in criminal proceedings all persons are, whatever their age, competent to give evidence. There are two exceptions. 1. A person is not competent to give evidence in criminal proceedings if it appears to the court that they are unable to understand questions put to them as a witness and give answers to them which can be understood. And 2. A person charged in criminal proceedings is not competent to give evidence in the proceedings for the prosecution, whether he is the only person or is one of two or more persons charged in the proceedings. And a co-accused can only give evidence for the prosecution once he or she ceases to be co-accused, for example, following a guilty plea. Lord Justice Bingham said, "The competent person should command the corpus of knowledge which forms part of the professional equipment of the ordinary member of his profession. The law does not require him to be a paragon, combining the qualities of a polymath and prophet." And that was Eckersley and other v. Binney and Partners. So that's some stuff that I've actually put together on how you assess competence. Qualifications do go towards assessing competence, but a qualification in isolation is not the only way you can assess competence, as I covered in that previous video. So I hope that helps. Have a great day. If you like what you hear, please share this with your colleagues. If you can add value to this and you have more information to this, then please add a comment below to help others. And once again, I hope that helps, and I'll speak to you all soon. Thank you.